Welcome, everyone. Today, we'll explore International Law 6th Edition by Malcolm N. Shaw, a definitive guide to understanding the complexities of international legal systems. This book is a cornerstone for students, academics, and practitioners alike, offering a comprehensive analysis of the rules, principles, and structures that govern relationships between nations, organizations, and individuals. The book begins by laying the foundations, delving into the nature, history, and sources of international law, such as treaties, customs, and general principles. It also examines how international law interacts with domestic legal systems around the world. Moving forward, it explores the subjects of international law, including states, organizations, and individuals, while addressing critical issues like human rights, criminal responsibility, and self-determination. Special attention is given to statehood, territory, the law of the sea, and environmental protections, all of which are vital in today's global challenges. Dispute resolution mechanisms, the role of the International Court of Justice, and the use of force by states are also discussed in detail, providing insight into how international conflicts are managed. Finally, the book dives into the functions of key institutions like the United Nations and explores specialized fields like humanitarian law and immunities. In essence, this is not just a textbook, but a comprehensive roadmap to understanding how the international legal framework shapes our world today. Let's dive into the first part, Section 1, the nature and development of international law. This section introduces the fundamental idea that international law serves as the legal framework for relations between states and other global actors. Unlike domestic law, which is enforced by a central authority, international law operates within a decentralized system where states voluntarily adhere to agreed-upon norms and principles. It balances law and politics, acknowledging the importance of power dynamics, while emphasizing the necessity of legal rules to maintain order and cooperation. Historically, international law has evolved from early practices of diplomacy and customs among ancient civilizations, such as the treaties of Mesopotamia or the laws governing trade in ancient Greece and Rome. A key milestone was the Peace of Westphalia in 1648, which established the principles of state sovereignty and non-interference. These principles remain cornerstones of international law today, governing how states interact while respecting territorial integrity. For instance, international law is applied in the prohibition of force under the United Nations Charter. An example is the response to Iraq's invasion of Kuwait in 1990. The international community, through the United Nations, condemned the aggression and authorized military action to restore Kuwait's sovereignty. This demonstrates how legal norms influence state behavior, even in a politically charged environment. Another example is the legal regulation of global commons, such as the high seas or outer space. Treaties like the United Nations Convention on the Law of the Sea, UNCLOS, ensure that no single state can claim ownership, promoting shared use and cooperation for resources like fisheries and seabed minerals. This section also highlights the interplay between law and power. While powerful states often shape international rules, smaller states use international law to protect their interests, especially in disputes over boundaries or resources. For instance, the International Court of Justice, ICJ, has resolved territorial disputes, such as the maritime boundary case between Peru and Chile in 2014, ensuring fairness through legal adjudication. In essence, the section demonstrates that international law is not just a set of abstract principles, but a practical system designed to facilitate peaceful coexistence and address global challenges. It evolves continuously, shaped by history, politics, and the pressing needs of an interconnected world. Let's move to Part 1, Section 2, International Law Today. This section takes us into the vibrant, dynamic reality of international law in the modern era. It emphasizes how international law has expanded far beyond the traditional focus on state-to-state relations, delving into areas like environmental protection, human rights, global trade, and even cyberspace. The key message here is that international law is no longer static. It's adapting and responding to an interconnected, fast-paced world. Take the example of climate change. Modern international law plays a crucial role in fostering cooperation through agreements like the Paris Agreement. This landmark treaty brings together nations to commit to reducing greenhouse gas emissions, aiming to limit global warming. It demonstrates how international law has shifted to address global challenges that transcend borders. States, though sovereign, agree to shared obligations because the problem, climate change, affects everyone. Another compelling example is the rise of international criminal law, which targets individuals for heinous crimes like genocide and war crimes. The International Criminal Court, ICC, is a modern institution that exemplifies this shift. Think of cases like the prosecution of leaders for war crimes in the Democratic Republic of the Congo. This represents a move from state immunity to holding individuals accountable for acts that violate humanity's shared moral and legal principles. The section also discusses the fragmentation of international law, where legal norms sometimes overlap or conflict. For instance, trade law under the World Trade Organization, WTO, may clash with environmental obligations under treaties like the Convention on Biological Diversity. Resolving these conflicts is a significant challenge, but also a testament to the complexity and richness of the modern legal system. A fascinating example of this fragmentation is in cyberspace regulation. The rise of technology has forced international law to address cyber attacks and data security. When nation-states face accusations of cyber espionage, like the alleged interference in elections, international legal norms provide a framework for diplomatic and legal responses, though the field is still evolving. In summary, international law today is a living, breathing system that's deeply intertwined with the realities of our world. Whether it's climate change, human rights, or technology, it's constantly adapting, innovating, and seeking ways to promote fairness, stability, and cooperation in an ever-changing global landscape. It's not just rules, it's the glue holding the international community together.
What do you think about this video? Leave a comment below.
Now let's dive into Part 1, Section 3, Sources of International Law. This section is the backbone of understanding how international law is created, identified, and applied. Unlike domestic legal systems, which have codified statutes or constitutions, international law relies on a variety of sources that reflect the decentralized nature of the global system. The main sources include customary international law, treaties, general principles of law, and subsidiary means such as judicial decisions and the writings of scholars. Let's start with customary international law, which develops from consistent state practice followed out of a sense of legal obligation, opinio juris. For example, the principle of non-intervention, that states should not interfere in the internal affairs of other states, emerged as customary law through repeated practice over centuries. A modern-day application is the prohibition of the use of force, which is enshrined in the UN Charter, but is also a well-established custom. Think about how the international community responded to Russia's annexation of Crimea in 2014. It was widely condemned as violating both treaty law and customary principles of territorial sovereignty. Next, we have treaties, which are formal agreements between states and are binding upon the parties. A prime example is the Treaty on the Non-Proliferation of Nuclear Weapons, NPT, which sets out obligations to prevent the spread of nuclear weapons. Treaties are critical because they allow states to address specific global issues in a legally binding way, from trade agreements like the WTO framework to environmental treaties like the Kyoto Protocol. General principles of law are another source, often derived from domestic legal systems and applied universally. For instance, the principle of good faith, which ensures that states honor their obligations, is used in treaty interpretation and international disputes. This principle was central in cases like the North Sea Continental Shelf case, where the International Court of Justice emphasized equitable principles in determining maritime boundaries. Lastly, judicial decisions and scholarly writings act as subsidiary sources. For example, decisions from the International Court of Justice, ICJ, or arbitral tribunals often clarify legal principles. The ICJ's decision in the Nicaragua case, 1986, reinforced the customary prohibition on the use of force and the principle of non-intervention. These rulings helped to develop and solidify international norms. Together, these sources form a flexible and adaptive system. Custom evolves with practice, treaties address specific needs, general principles provide foundational fairness, and judicial decisions guide interpretation. Whether it's resolving territorial disputes, managing global trade, or addressing climate challenges, these sources collectively shape the ever-developing fabric of international law. Let's move on to Part 2, Section 1, International Law and Municipal Law. This section focuses on the interaction between international law and the domestic legal systems of states, highlighting the fundamental question: how do global rules operate within a state's internal legal framework? The relationship is shaped by two primary theories, monism and dualism, and varies across legal systems. Under monism, international law is directly integrated into domestic law without requiring additional legislation. For instance, in the Netherlands, international treaties automatically have domestic legal effect once ratified. A practical example is the European Convention on Human Rights, ECHR, which Dutch courts have applied directly in cases involving human rights violations, such as the landmark Önür Yıldız, Turkey, addressing the right to life in environmental disasters. In contrast, dualism emphasizes a clear separation between international and domestic law. Here, international law must be explicitly incorporated into domestic legislation to be enforceable. The UK is a prime example. While the UK recognizes international law, treaties like the European Convention on Human Rights only became enforceable domestically after the Human Rights Act 1998 incorporated them. This dualist approach can create situations where a state may be bound by international obligations externally but unable to enforce them domestically until legislative action is taken. One fascinating example of the interplay between these systems is the case of the US and international climate agreements, such as the Paris Agreement. The US is bound internationally by the treaty, but domestically, the implementation depends on congressional approval for laws aligning with the treaty's goals. This highlights how dualist systems can complicate the enforcement of international obligations. Additionally, the section covers situations where domestic courts apply customary international law. In the United States, customary law is often treated as part of the common law. For instance, the Paquete Habana case in 1900 affirmed that customary norms, like exempting fishing vessels from capture during wartime, are binding in U.S. courts unless overridden by statutes. Finally, conflicts may arise when international obligations clash with domestic laws. For example, the German Constitutional Court ruled in the Lisbon Treaty case that while Germany supports European Union integration, it must ensure that EU laws comply with the German Constitution. This demonstrates the tension between sovereignty and international commitments. In essence, this section shows how international and municipal laws coexist, sometimes harmoniously and sometimes contentiously. The relationship is vital because it determines how global norms influence state behavior and ensure accountability at all levels of governance. Let's explore Part 3, Section 1, the subjects of international law. This section examines the entities that hold rights and obligations under international law, allowing them to actively participate in the international legal system. While states have historically been the primary subjects, the modern legal landscape recognizes other entities, including international organizations, individuals, and in some cases, non-state actors. States are the principal subjects, possessing full sovereignty and legal personality. This means they can engage in treaties, claim territorial rights, and be held accountable under international law. A key example is the Montevideo Convention on the Rights and Duties of States, 1933, which outlines the criteria for statehood: a permanent population, defined territory, government, and capacity to enter into relations with other states. An application of this principle is the recognition of South Sudan as a state in 2011 after meeting these criteria, demonstrating how states are formalized as legal entities in the global system. Beyond states, international organizations have gained significant recognition as subjects of international law. These entities, such as the United Nations, UN, or the World Trade Organization, WTO, have distinct legal personalities, enabling them to act independently of member states. For example, the UN has the capacity to conclude agreements and bring legal claims. A landmark case is the Reparations for Injuries case, 1949, where the International Court of Justice, ICJ, confirmed the UN's right to seek reparations for injuries to its personnel, reinforcing its status as a subject of international law. The modern framework also acknowledges individuals as subjects of international law, particularly in the realm of human rights and international criminal law. Individuals can now be held personally accountable for violations like genocide, war crimes, and crimes against humanity. This principle was pioneered during the Nuremberg trials after World War II and continues through the work of the International Criminal Court, ICC. A notable case is that of Omar al-Bashir, the former president of Sudan, who was indicted by the ICC for his role in atrocities in Darfur. This represents a shift in international law from focusing solely on states to addressing individual accountability. Lastly, non-state actors, such as insurgent groups and multinational corporations, have limited but growing recognition. Insurgent groups, for instance, are bound by international humanitarian law in armed conflicts, such as the obligations under the Geneva Conventions. Similarly, corporations are increasingly held accountable for human rights and environmental violations. An example is the case against Shell in Nigeria, where the company faced legal scrutiny for its alleged role in environmental damage and human rights abuses. In essence, this section highlights the expanding scope of international law to include diverse actors, reflecting the complexities of a globalized world. By recognizing not just states, but also organizations, individuals, and non-state entities, international law adapts to address modern challenges and ensure accountability on multiple levels. Now, let's dive into Part 4, Section 1. The International Protection of Human Rights. This section highlights one of the most transformative developments in international law, the recognition and protection of fundamental human rights at a global level. Unlike traditional international law, which primarily governed relations between states, human rights law focuses on the relationship between states and individuals, ensuring that governments respect, protect, and fulfill the basic rights of their populations. The modern framework for human rights began after World War II, with the establishment of the United Nations and the adoption of the Universal Declaration of Human Rights, UDHR, in 1948. The UDHR laid out a universal set of principles such as the right to life, freedom from torture, and equality before the law. Although not legally binding, the Declaration has inspired legally binding treaties like the International Covenant on Civil and Political Rights, ICCPR, and the International Covenant on Economic, Social, and Cultural Rights, ICSCR, collectively forming the International Bill of Rights. One concrete example of the application of human rights law is the prohibition of genocide under the Genocide Convention, 1948. This was evident in the prosecution of individuals responsible for the Rwandan genocide at the International Criminal Tribunal for Rwanda, ICTR, demonstrating that international law can hold individuals accountable for violations of human rights. Additionally, regional systems play a critical role in protecting human rights. For instance, the European Court of Human Rights, ECHR, under the European Convention on Human Rights, has addressed thousands of cases, ensuring justice for individuals whose rights were violated. A notable example is the case of Osman V, United Kingdom, where the court ruled that the UK had failed to protect the right to life of a family threatened by a stalker. This case underscored the state's duty to protect individuals from harm. The section also emphasizes collective rights, such as the right to self-determination, which allows peoples to freely determine their political status and pursue economic, social, and cultural development. This principle was key in the decolonization movements of the 20th century, enabling nations like Namibia to gain independence. While human rights law has made significant progress, enforcement remains a challenge. Cases like the ongoing crisis involving the Rohingya people in Myanmar highlight the limitations of international mechanisms when states refuse to cooperate or when political interests override justice. In summary, this section illustrates how international law has expanded its scope to prioritize the dignity and rights of individuals. By creating universal principles, enforcing them through treaties and courts, and addressing both individual and collective rights, the international community has made human rights a cornerstone of global governance. However, the journey to universal compliance continues, requiring persistent effort and cooperation. Let's explore Part 4, Section 2, the regional protection of human rights. While international human rights frameworks like the United Nations play a global role, regional systems have emerged as powerful tools to protect and promote human rights within specific geographical and cultural contexts. These systems recognize the diversity of regions and allow for tailored approaches that address local challenges more effectively. The European system, under the Council of Europe, is perhaps the most developed. Its cornerstone is the European Convention on Human Rights, ECHR, which established the European Court of Human Rights, ECHR. This court allows individuals to bring cases against their governments for human rights violations. A notable example is the case of Loizido v. Turkey, where the ECTHR ruled in favor of a Cypriot citizen whose property rights were violated due to Turkey's military intervention in northern Cyprus. The decision reaffirmed the right to property and held Turkey accountable, showcasing the court's ability to provide justice at a regional level. In the Americas, the Inter-American System, governed by the Organization of American States, OAS, operates under the American Convention on Human Rights. The Inter-American Court of Human Rights and Inter-American Commission on Human Rights have addressed critical cases such as the Barrios Altos v. Peru case, which ruled against the Peruvian government's use of amnesty laws to shield perpetrators of human rights violations during internal conflicts. This decision reinforced the principle that justice cannot be sacrificed for political convenience. Africa's regional framework is anchored by the African Charter on Human and People's Rights, overseen by the African Commission on Human and People's Rights, and the African Court on Human and People's Rights. One impactful case was the Ogoni people v. Nigeria, where the African Commission found the Nigerian government responsible for violating the rights of the Ogoni people due to environmental damage caused by oil extraction. This case highlighted the intersection of human rights and environmental justice, a growing concern in the region. Other regional systems, such as the Arab Charter on Human Rights and the ASEAN Human Rights Declaration, are less robust but still reflect efforts to localize human rights protection. For example, ASEAN's work focuses on promoting rights in a manner consistent with the region's values and traditions, even though enforcement remains a challenge. These regional systems are critical because they complement global frameworks by addressing specific cultural, political, and historical contexts. They often provide more accessible mechanisms for individuals to seek justice and help ensure that human rights are not just theoretical ideals, but actionable protections tailored to regional realities. However, challenges such as political interference and limited enforcement remain, making the continued strengthening of these systems vital for ensuring meaningful human rights protection across the world. Let's turn to Part 4, Section 3, Individual Criminal Responsibility in International Law. This section represents a groundbreaking shift in international law, emphasizing that individuals, not just states, can be held accountable for violations of international norms. This evolution underscores the idea that crimes of the most serious nature, such as genocide, war crimes, and crimes against humanity, cannot go unpunished, no matter who commits them. One of the most pivotal examples of individual criminal responsibility comes from the Nuremberg trials after World War II. These trials marked the first time that individuals were prosecuted for crimes against humanity, genocide, and war crimes under international law. Nazi leaders were held accountable, establishing the principle that following orders is no defense for committing atrocities. This set the precedent that individuals, including heads of state, are not above the law. Building on this, modern international criminal law has developed institutions like the International Criminal Tribunal for the former Yugoslavia, ICTY, and the International Criminal Tribunal for Rwanda, ICTR. The ICTY, for instance, prosecuted individuals responsible for crimes committed during the Yugoslav wars, such as the Srebrenica massacre. One notable conviction was that of Ratko Mladic, the former Bosnian Serb military leader, who was sentenced for genocide and crimes against humanity. Similarly, the ICTR prosecuted key figures responsible for the Rwandan genocide, including Jean-Paul Akayesu, whose conviction established rape as a form of genocide. The creation of the International Criminal Court, ICC, in 2002 further solidified the global commitment to individual accountability. The ICC has handled high-profile cases such as the trial of Thomas Lubanga, who was convicted of recruiting child soldiers in the Democratic Republic of the Congo. This case not only delivered justice, but also raised awareness of the need to protect children in conflict zones. Additionally, hybrid courts, such as the Special Court for Sierra Leone, have addressed crimes in specific contexts, blending international and domestic law. This court successfully prosecuted Charles Taylor, the former president of Liberia, for his role in fueling civil wars and atrocities in Sierra Leone. It demonstrated that even sitting leaders can face justice for their actions. Importantly, this section also discusses the challenges of enforcement and the limitations of international criminal law. For example, political pressures often affect the ability to arrest and prosecute suspects, as seen in the difficulty of apprehending leaders like Omar al-Bashir of Sudan, despite an ICC arrest warrant for genocide in Darfur. In summary, this section highlights how international law has evolved to ensure that individuals, no matter their position or power, are held accountable for the gravest crimes. Through institutions like the ICC, ad hoc tribunals, and hybrid courts, the principle of individual responsibility has become a cornerstone of international justice, striving to end impunity and prevent future atrocities. Let's explore Part 5, Section 1, Recognition. Recognition is a fundamental concept in international law as it determines how states and governments are acknowledged as legitimate actors within the international community. Recognition can apply to new states, new governments, or specific situations like territorial claims, and it plays a crucial role in ensuring stability and order in international relations. When it comes to recognizing states, a common example is the emergence of South Sudan in 2011. After a referendum that overwhelmingly supported independence, South Sudan declared itself a sovereign state. Recognition by other states and its subsequent admission to the United Nations solidified its status as a legitimate member of the international community. However, recognition is often influenced by politics. For instance, Taiwan functions as a de facto independent state, yet many countries, including powerful nations, do not officially recognize it due to political and diplomatic considerations involving China. Recognition can also apply to governments, especially during regime changes or civil wars. For example, after the Libyan civil war in 2011, the international community faced a question of whether to recognize the National Transitional Council, NTC, as the legitimate government of Libya, replacing Muammar Gaddafi's regime. The recognition of the NTC by major powers like the United States and European Union countries was pivotal in granting it international legitimacy and access to Libyan assets abroad. Another key aspect is the distinction between de facto and de jure recognition. De facto recognition acknowledges that an entity has effective control over a territory, but stops short of legally endorsing it. For example, many countries consider Northern Cyprus as a de facto entity controlled by Turkish Cypriots, but do not grant it de jure recognition due to its lack of compliance with international norms and opposition from the Republic of Cyprus. In addition, recognition often intersects with territorial disputes. Take the case of Crimea, which Russia annexed in 2014. While Russia claims sovereignty over Crimea, most of the international community, including the United Nations, does not recognize the annexation and continues to consider Crimea as part of Ukraine. This lack of recognition demonstrates how international law can be used to challenge actions deemed illegal under global norms, such as violations of territorial integrity. Recognition also has legal effects domestically and internationally. For instance, recognition allows states or governments to enter treaties, establish diplomatic relations, and participate in international organizations. However, it is not obligatory. States retain discretion in deciding whether to recognize an entity, leading to inconsistencies in the global system. In summary, recognition is a powerful legal and political tool in international law. It not only validates the existence or legitimacy of states and governments, but also shapes their ability to interact within the global system. By addressing real-world examples like South Sudan, Taiwan, and Crimea, this section highlights the critical role of recognition in maintaining or challenging international order. Now let's move on to Part 5, Section 2, Territory. This section examines one of the most essential concepts in international law, territory. Territory is a defining characteristic of statehood, as it provides the physical space over which a state exercises sovereignty. International law governs how states acquire, control, and resolve disputes over territory, making it a crucial aspect of maintaining global order. States can acquire territory through several recognized methods under international law. One of the most common is cession, where one state transfers territory to another, often through a treaty. A famous example is the Louisiana Purchase in 1803, where France ceded a vast tract of land to the United States, significantly expanding its territory. Another method is accretion, where natural processes, such as the gradual buildup of land due to sediment deposition, expand a state's territory. Occupation is another key principle, referring to the acquisition of territory that was previously terra nullius, territory belonging to no one. The case of Western Sahara, adjudicated by the International Court of Justice, ICJ, in 1975, is a prime example. The ICJ ruled that Western Sahara was not terra nullius before its colonization by Spain, affirming the right of its indigenous people to self-determination. One of the most contentious methods is effective control, often arising in territorial disputes. For example, the Falkland Islands dispute between the United Kingdom and Argentina hinges on questions of historical claims and effective administration. The UK maintains sovereignty over the islands based on its long-standing governance, while Argentina claims the territory based on historical proximity and prior possession. International law also governs boundary disputes, ensuring peaceful resolution through legal principles and mechanisms. The ICJ has played a central role in resolving such disputes. For instance, in the maritime boundary dispute between Cameroon and Nigeria, the ICJ in 2002 awarded sovereignty over the Bakassi Peninsula to Cameroon, emphasizing the importance of treaty provisions and effective control in determining territorial ownership. The concept of territorial integrity is another critical topic, which prohibits states from violating another state's territorial sovereignty. This principle is enshrined in the United Nations Charter and has been invoked in numerous cases, such as the international community's condemnation of Russia's annexation of Crimea in 2014. Furthermore, international law addresses special territorial regimes like Antarctica and outer space, which are designated as global commons. The Antarctic Treaty System ensures that Antarctica is used exclusively for peaceful purposes and scientific research, preventing any single state from claiming sovereignty. Similarly, the Outer Space Treaty declares outer space as a domain for all humanity, prohibiting territorial claims. In summary, territory is more than just physical space. It is a fundamental element of sovereignty and statehood. By regulating acquisition, boundary disputes, and special regimes, international law seeks to promote stability and cooperation among states. Cases like the Falklands, Crimea, and Antarctica illustrate the complexities of territorial issues and the critical role of international law in addressing them peacefully. Let's dive into Part 5, Section 3, the Law of the Sea. This section focuses on the legal framework that governs the use of the world's oceans, which cover over 70% of the Earth's surface. The law of the sea ensures the peaceful use of maritime spaces, facilitates international trade, and promotes the sustainable management of marine resources. The cornerstone of this body of law is the United Nations Convention on the Law of the Sea, often referred to as the Constitution of the Oceans. One of the most important concepts in this section is the division of maritime zones, each with distinct legal regimes. For example, the territorial sea, which extends up to 12 nautical miles from a state's baseline, grants states sovereignty over the waters, seabed, and airspace. However, this sovereignty is balanced by the right of innocent passage, allowing foreign vessels to traverse these waters without interference, as long as they don't threaten the coastal state's security. Beyond the territorial sea lies the Exclusive Economic Zone, EEZ, which extends up to 200 nautical miles. Within this zone, a state has special rights over the exploration and exploitation of marine resources, such as fishing and oil extraction. A well-known example is the dispute in the South China Sea, where overlapping claims to EEZs among China, the Philippines, Vietnam, and others have led to tensions. The Permanent Court of Arbitration, PCA, ruled in 2016 that China's expansive claims based on its 9-dash line were inconsistent with UNCLOS, underscoring the importance of international law in resolving such disputes. The continental shelf is another critical area where states can claim rights to seabed resources, even beyond the EEZ, if they can prove the natural prolongation of their land territory. For example, Russia has submitted claims to the Arctic seabed, including the resource-rich Lomonosov Ridge, based on its interpretation of geological data. These claims are evaluated by the Commission on the Limits of the Continental Shelf under UNCLOS. The high seas, which lie beyond national jurisdiction, are open to all states for activities like navigation, fishing, and scientific research. However, challenges like overfishing, piracy, and pollution have prompted international cooperation to regulate these areas. One example is the fight against piracy off the coast of Somalia, where naval coalitions and legal frameworks like UNCLOS have been crucial in addressing the threat. The section also emphasizes the protection of the marine environment. Under UNCLOS, states are obligated to prevent pollution and sustainably manage marine resources. Initiatives like the International Maritime Organization's regulations on ship emissions and ballast water management are examples of how global standards address environmental challenges. Finally, the section discusses dispute resolution mechanisms under UNCLOS, such as the International Tribunal for the Law of the Sea, ITLS, and arbitration panels. These bodies provide legal avenues for resolving conflicts, as seen in cases like the Bangladesh-Myanmar maritime boundary dispute, where ITLOS delivered a fair and binding judgment based on legal principles. In summary, the law of the sea is vital for ensuring the equitable use and protection of the world's oceans. By balancing state sovereignty with international cooperation, It addresses issues ranging from territorial claims and resource management to environmental conservation and dispute resolution, making it a cornerstone of modern international law.
Join our community by subscribing and be part of our journey.
Let's dive into Part 6, Section 1, Jurisdiction. Jurisdiction refers to the legal authority of a state to make, enforce, and adjudicate laws within its territory and, in certain circumstances, beyond its borders. This section examines the various principles that define how states exercise jurisdiction, balancing their sovereignty with the need for international cooperation and order. The primary type of jurisdiction is territorial jurisdiction, where a state exercises authority over acts, individuals, or property within its territory. For instance, if a crime is committed in France, French courts have the authority to prosecute the offender, regardless of their nationality. A practical example is the prosecution of terrorism suspects who plan or commit attacks within a state's borders, such as the investigations following the Paris attacks in 2015. However, jurisdiction is not limited to territorial boundaries. States can claim personal jurisdiction based on nationality, allowing them to regulate the behavior of their citizens abroad. For example, the United States enforces tax laws on its citizens no matter where they live, requiring them to file annual tax returns, even if they reside in a foreign country. Another principle is protective jurisdiction, which permits a state to act against offenses committed outside its territory if they threaten its security or vital interests. A clear example is countering cyber attacks originating from another country, but targeting critical national infrastructure such as the 2020 SolarWinds hack that affected U.S. government systems. Here, jurisdiction is invoked to protect the state's sovereignty and security. The universality principle is particularly significant in addressing heinous crimes that affect the international community as a whole, such as genocide, piracy, or war crimes. Under this principle, any state can prosecute offenders, regardless of where the crime occurred or the nationality of the perpetrator. A well-known example is the prosecution of Adolf Eichmann, a Nazi official, by Israel for his role in the Holocaust under the principle of universal jurisdiction. Additionally, extraterritorial jurisdiction arises when a state extends its laws to activities occurring abroad. This is common in cases involving multinational corporations. For instance, under the U.S. Alien Tort Statute, foreign plaintiffs have sued corporations for alleged human rights abuses committed overseas, as in the case of Kiobel v. Royal Dutch Petroleum. This section also highlights the challenges and conflicts that arise when multiple states assert jurisdiction over the same matter, leading to jurisdictional disputes. For example, in cross-border data privacy cases, such as the European Union's General Data Protection Regulation (GDPR) enforcement against US-based tech companies, questions arise about whose laws prevail. In summary, jurisdiction is a core concept that defines the scope of a state's authority and its interaction with international law. Whether addressing crimes, regulating businesses, or protecting national security, jurisdiction serves as the legal framework for balancing sovereignty with global interconnectivity. Examples like counterterrorism, piracy, and international corporate accountability demonstrate its practical and evolving importance in today's world. Let's dive into Part 6, Section 2, Immunities from Jurisdiction. This section addresses a key principle of international law. Certain individuals, entities, and states are granted immunity from the jurisdiction of foreign courts to ensure the smooth functioning of international relations and diplomacy. Immunity is a critical balance between respecting sovereignty and ensuring justice, often creating a tension between legal accountability and state privilege. The most well-known form is sovereign immunity, which protects states and their organs from being sued in foreign courts without their consent. This principle, rooted in the idea that all states are equal, ensures that one state cannot impose its authority over another. For example, in the case of Germany v. Italy, 2012, the International Court of Justice reaffirmed that Germany had immunity from Italian court claims related to World War II atrocities, despite the grave nature of the allegations. This demonstrates how immunity safeguards state sovereignty, even in highly sensitive contexts. Diplomatic immunity, another crucial aspect, protects diplomats and their missions from interference by the host state. This immunity is codified in the Vienna Convention on Diplomatic Relations, 1961. For instance, diplomats cannot be prosecuted for crimes committed in the host country. A well-known case is the 1984 shooting of a police officer from within the Libyan embassy in London. While the UK could not prosecute Libyan diplomats due to their immunity, it severed diplomatic ties with Libya, showcasing how states navigate the complexities of immunity while seeking justice. At the individual level, head of state immunity protects sitting heads of state from prosecution in foreign courts. For example, during his presidency, Robert Mugabe of Zimbabwe was shielded from lawsuits abroad despite widespread allegations of human rights abuses. However, this immunity typically ends once a leader leaves office, as seen in the prosecution of Sudan's former president, Omar al-Bashir, by the International Criminal Court, ICC, for crimes committed in Darfur. There are also exceptions to immunity, particularly when commercial or private acts, referred to as acta jure gestionis, are involved. For example, if a foreign state engages in a commercial transaction, it can be subject to legal action in another country. This principle was applied in the case of Argentina v. NML Capital Ltd. 2014, where Argentina's sovereign immunity was limited due to its issuance of bonds, a commercial activity. Finally, international organizations also enjoy immunity to ensure their independence and functionality. For instance, the United Nations and its personnel are protected under the UN Charter. However, controversies arise when immunity shields organizations from accountability, such as in the Haiti cholera outbreak linked to UN peacekeepers, where victims faced obstacles in seeking justice due to the organization's immunity. In summary, immunities from jurisdiction are vital for maintaining international diplomacy, cooperation, and stability. However, they also present challenges, particularly when immunity appears to conflict with justice and accountability. Cases like the Libyan embassy shooting, the Mugabe presidency, and the Haiti cholera crisis illustrate the delicate balance that immunity seeks to achieve in the complex world of international law.
Join our community by subscribing and be part of our journey.
Let's turn our focus to Part 7, Section 1, International Environmental Law. This section explores how international law addresses one of the most pressing challenges of our time, the protection and preservation of the global environment. With environmental issues crossing borders, such as climate change, deforestation, and pollution, international cooperation is essential to manage shared resources and mitigate harm. A cornerstone of international environmental law is the concept of sustainable development, which seeks to balance economic growth, environmental protection, and social equity. This principle was prominently highlighted in the Rio Declaration on Environment and Development, 1992, which set the stage for global environmental governance. The declaration introduced key principles like the precautionary principle, preventing harm even in the absence of scientific certainty, and the polluter pays principle, which requires polluters to bear the costs of environmental damage. A prime example of international environmental law in action is the Paris Agreement 2015 under the United Nations Framework Convention on Climate Change, UNFCCC. The agreement brought nations together to combat climate change by limiting global temperature rise to well below 2 degrees Celsius above pre-industrial levels. Countries submit nationally determined contributions, NDCs, outlining their plans to reduce emissions. The Paris Agreement illustrates how international law fosters cooperation to address a global crisis that no single state can solve alone. Transboundary pollution is another critical issue addressed by international environmental law. The Trail Smelter Arbitration 1938 to 1940-1941 set a precedent by holding Canada accountable for pollution from a smelter that damaged U.S. territory. This case established the principle that states must ensure activities within their jurisdiction do not cause harm to other states, a principle that remains foundational in environmental law today. The protection of biodiversity is also a significant focus, as seen in the Convention on Biological Diversity, CBD, This treaty promotes the conservation of biological diversity, sustainable use of its components, and the fair sharing of benefits arising from genetic resources. For example, the treaty has been instrumental in addressing deforestation and preserving ecosystems critical for global biodiversity. Marine protection is another key area governed by the United Nations Convention on the Law of the Sea, UNCLOS. UNCLOS establishes obligations for states to prevent marine pollution, manage fisheries sustainably, and protect vulnerable ecosystems. An example is the regulation of overfishing in the high seas through agreements like the UN Fish Stocks Agreement, which ensures cooperation in managing migratory fish stocks. Finally, international environmental law includes mechanisms to resolve disputes and ensure compliance. For instance, the International Court of Justice, ICJ, and arbitration bodies have been used to address disputes over environmental harm. In the case of pulp mills on the river Uruguay, Argentina v. Uruguay, the ICJ ruled on environmental impacts caused by a paper mill on a shared waterway, emphasizing the need for cooperation and environmental assessments in transboundary projects. In summary, international environmental law is a vital and dynamic area that seeks to protect our shared planet. Through treaties like the Paris Agreement, principles like sustainable development, and cases like Trail Smelter, it demonstrates the global commitment to addressing environmental challenges while balancing the needs of states and the global community. Now let's focus on Part 7, Section 2, the Law of Treaties. Treaties are one of the most critical instruments in international law, serving as formal agreements between states or international organizations to create binding legal obligations. This section explores the formation, interpretation, and enforcement of treaties, all governed by the Vienna Convention on the Law of Treaties, VCLT, 1969, often referred to as the Treaty on Treaties. The process of treaty formation begins with negotiation, where states or parties agree on terms, followed by signature and ratification. Ratification is essential because it demonstrates a state's formal consent to be bound by the treaty. For example, the Paris Agreement, 2015, on climate change required countries to ratify the treaty for it to take effect. When major emitters like the United States and China ratified it, the agreement gained the necessary momentum for global enforcement. The interpretation of treaties is another vital area, guided by Articles 31 and 32 of the VCLT, which emphasize good faith and the ordinary meaning of treaty terms in their context. For instance, in the case of Ecuador vs. United States, 2021, the interpretation of a bilateral investment treaty hinged on how the terms investment and fair treatment were understood, demonstrating how treaty language can shape obligations and disputes. The section also examines the invalidity and termination of treaties, which may occur under specific conditions. A treaty can be considered invalid if it was signed under coercion or if it conflicts with a peremptory norm, jus cogens, a fundamental principle of international law like the prohibition of genocide. For example, any treaty attempting to legalize slavery would be void because it violates jus cogens norms. Termination can also occur by mutual consent, breach, or fundamental changes in circumstances, extantibus. An example is the U.S. withdrawal from the Intermediate Range Nuclear Forces Treaty, INF Treaty, in 2019, citing Russian violations and changing security dynamics. This illustrates how treaties can adapt or dissolve when the underlying conditions that justified them no longer exist. Another critical aspect is state succession and treaties, which determines whether a newly formed state inherits the treaty obligations of its predecessor. For example, when the Soviet Union dissolved, Russia succeeded to many of its treaties, including arms control agreements, maintaining continuity in international obligations. The enforcement of treaty obligations often depends on dispute resolution mechanisms within the treaty or external bodies like the International Court of Justice, ICJ, or arbitration panels. For example, in the Gabčíkovo-Najmaros project case, Hungary v. Slovakia, the ICJ resolved a dispute over a treaty to construct dams on the Danube River, ruling on the obligations of both states and the treaty's continuing relevance. In summary, the law of treaties is the backbone of international cooperation, providing a structured way for states to create, interpret, and enforce agreements. From climate treaties like the Paris Agreement to boundary treaties and trade agreements, treaties underpin much of international relations. Their regulation under the VCLT ensures consistency, fairness, and legal predictability in global governance. Let's dive into Part 8, Section 1. State succession. This section deals with the legal consequences that arise when one state replaces another in control over a territory, which can occur due to events like decolonization, mergers, dissolutions, or secession. State succession is a complex area of international law because it affects treaties, debts, assets, and obligations, and raises questions about continuity and change in international legal relations. A significant example of state succession is the dissolution of the Soviet Union in 1991. When the USSR broke apart, 15 independent states emerged, including Russia, Ukraine, and Kazakhstan. Russia was recognized as the continuing state of the Soviet Union, inheriting its UN Security Council seat, treaties, and international obligations. The other newly independent states, as successor states, had to negotiate their own treaty obligations and relationships with the international community. This illustrates how state succession can preserve continuity while also allowing for new beginnings. In cases of decolonization, state succession often involves newly independent states deciding whether to honor the treaties signed by their former colonial rulers. For instance, when India gained independence in 1947, it chose to selectively adopt treaties that aligned with its interests, demonstrating the flexibility states have under the Vienna Convention on Succession of States in Respect of Treaties, 1978. State succession also has significant implications for national debts and assets. The breakup of Yugoslavia in the 1990s provides a compelling example. As Yugoslavia fragmented into several states, questions arose about the distribution of its debts and assets, such as embassies, military equipment, and foreign reserves. The issue was resolved through negotiation, with successor states like Serbia, Croatia, and Bosnia agreeing to proportionate shares based on factors like population and territory. Another critical aspect is the succession of obligations related to human rights and state responsibility. After the reunification of Germany in 1990, the unified German state assumed responsibility for the actions of East Germany, including human rights abuses committed during the Cold War. This continuity ensured accountability while integrating the two states into one legal entity. However, not all cases of state succession are smooth. The ongoing issue of Taiwan illustrates the complexity. While Taiwan operates as a de facto independent state, most of the international community does not recognize it as the successor state to the Republic of China, in a legal sense, due to political considerations involving China. In summary, state succession is a crucial area of international law that ensures a balance between continuity and change when states undergo significant transformations. Whether through the dissolution of the Soviet Union, the breakup of Yugoslavia, or decolonization processes, state succession shapes how states inherit rights and obligations, providing a legal framework for navigating the transition. Now let's focus on Part 8, Section 2, the settlement of disputes by peaceful means. This section highlights a cornerstone of international law, the obligation of states to resolve their disputes peacefully, as outlined in Article 2.3 of the United Nations Charter. This principle aims to prevent conflict and maintain international stability through a variety of mechanisms, from diplomacy to judicial proceedings. One of the most widely used methods is negotiation, where states engage directly to resolve disagreements. For example, the long-standing border dispute between India and Bangladesh over enclaves was resolved through negotiation, culminating in the 2015 Land Boundary Agreement. By peacefully negotiating terms, the two countries avoided escalation and reached a mutually beneficial solution. Another method is mediation, where a neutral third party facilitates dialogue between the disputing states. A notable example is the Camp David Accords 1978, where U.S. President Jimmy Carter mediated between Egypt and Israel, leading to a historic peace agreement. Mediation is particularly effective when tensions are high, as it provides a platform for dialogue while maintaining impartiality. Arbitration is another popular mechanism involving a binding decision made by an impartial tribunal. The South China Sea arbitration case Philippines v. China is a prominent example. In 2016, the Permanent Court of Arbitration ruled against China's expansive claims in the South China Sea, favoring the Philippines. Although China rejected the ruling, the case underscores the role of arbitration in clarifying legal disputes under international law. The International Court of Justice, ICJ, is one of the most prominent forums for resolving disputes through adjudication. For instance, in the Nicaragua v. United States 1986 Sixro case, the ICJ ruled that the U.S. violated international law by supporting Contra rebels in Nicaragua. While the U.S. contested the decision, the case demonstrated the ICJ's ability to address state actions and interpret international legal principles. In addition to legal mechanisms, good offices is another peaceful approach, where a third party provides logistical support or a neutral venue for negotiations. For example, the United Nations often uses good offices to facilitate dialogue in conflict zones, such as its efforts to mediate in Cyprus. Lastly, regional organizations play a critical role in dispute resolution. The African Union, AU, and the Organization of American States, OAS, often mediate in regional conflicts, while the European Union, EU, has helped resolve trade and border disputes among its member states, such as those involving Northern Ireland during Brexit negotiations. In summary, peaceful dispute settlement is a foundational principle of international law that promotes stability and cooperation. Whether through negotiation, mediation, arbitration, or judicial processes, these mechanisms provide states with effective tools to resolve conflicts without resorting to violence. Examples like the South China Sea case, the Camp David Accords, and the ICJ's rulings illustrate how international law facilitates dialogue and accountability in a complex global landscape. Let's explore Part 8, Section 3, International Law and the Use of Force by States. This section examines one of the most critical and controversial aspects of international law: when and how states can legally resort to force. The overarching principle enshrined in Article 2.4 of the United Nations Charter is that states are prohibited from using force against the territorial integrity or political independence of another state. This principle serves as the foundation for maintaining global peace and security. However, there are specific exceptions to this prohibition. The first and most significant is the right to self-defense, outlined in Article 51 of the UN Charter. States may use force in response to an armed attack until the Security Council takes necessary measures. A well-known example is the United States response to the 9/11 attacks in 2001. The U.S. invoked Article 51 to justify its military intervention in Afghanistan, targeting al-Qaeda and the Taliban regime for harboring terrorists. This highlighted how self-defense extends to non-state actors in modern international conflicts. The second exception is the use of force authorized by the United Nations Security Council, UNSC, under Chapter 7 of the UN Charter. The UNSC can approve military action to restore international peace and security, as it did in response to Iraq's invasion of Kuwait in 1990. In this case, the UNSC passed Resolution 678, authorizing a coalition of states to use all necessary means to expel Iraqi forces from Kuwait, illustrating collective security in action. Another concept explored in this section is humanitarian intervention, which involves using force to prevent widespread human suffering or human rights violations. While not explicitly authorized by the UN Charter, this principle was invoked during NATO's intervention in Kosovo in 1999. NATO justified its actions as necessary to stop ethnic cleansing and atrocities against the Kosovo population, though the lack of explicit UNSC authorization remains a contentious point in international law. Additionally, the section discusses the responsibility to protect, R2P, a doctrine that emerged in the early 2000s to address mass atrocities such as genocide, war crimes, ethnic cleansing, and crimes against humanity. R2P was invoked during the Libyan Civil War in 2011 when the UNSC authorized military intervention under Resolution 1973 to protect civilians from the Gaddafi regime. While the intervention initially succeeded in preventing mass atrocities, it also raised questions about overreach and long-term consequences, highlighting the complexities of applying R2P. Lastly, the section addresses illegal uses of force, such as Russia's annexation of Crimea in 2014. This act violated Ukraine's territorial integrity and was widely condemned as a breach of Article 2.4. The international response included sanctions and non-recognition of the annexation, showcasing how international law and diplomacy work to uphold the prohibition on force. In summary, this section underscores the delicate balance between prohibiting force and allowing its use in exceptional circumstances. From self-defense in Afghanistan to humanitarian intervention in Kosovo and collective action in Kuwait, the principles governing the use of force aim to prevent conflict while addressing threats to peace. However, challenges like the Libya intervention and Crimea annexation highlight the ongoing tension between legal norms and geopolitical realities. Let's dive into Part 8, Section 4, International Humanitarian Law, IHL. This section addresses the laws governing armed conflicts, focusing on minimizing human suffering during war. Often called the laws of war, international humanitarian law seeks to balance military necessity with humanitarian considerations. It applies in both international and non-international armed conflicts and is rooted in key treaties like the Geneva Conventions, 1949, and their additional protocols. At its core, IHL is built around two fundamental principles: the distinction between combatants and civilians and the prohibition of unnecessary suffering. Combatants may be targeted, but civilians and civilian objects, such as schools and hospitals, must be spared. For example, during the Gulf War, 1990 to 1991, coalition forces adhered to IHL by using precision-guided weapons to avoid unnecessary civilian casualties, although debates arose about the extent of compliance in certain operations. A crucial aspect of IHL is the prohibition of certain weapons and tactics deemed inhumane. For instance, the use of chemical and biological weapons is banned under the Chemical Weapons Convention 1993 and the Biological Weapons Convention 1972. A recent example is the international outcry against the alleged use of chemical weapons in Syria's civil war, which violated these conventions and sparked investigations and sanctions. IHL also imposes obligations to care for the wounded and sick, regardless of their allegiance. This is exemplified in the work of the International Committee of the Red Cross, ICRC, which provides neutral humanitarian assistance in conflict zones. For instance, in the conflict in Yemen, the ICRC has facilitated the exchange of prisoners and provided medical aid to civilians, demonstrating the practical application of IHL's principles. Another key area of IHL is the protection of prisoners of war, POWs. Under the Third Geneva Convention, POWs must be treated humanely, protected from violence, and granted access to the ICRC. Violations of these rules have occurred in numerous conflicts, such as the mistreatment of detainees at Abu Ghraib prison during the Iraq War, which triggered international condemnation and legal proceedings. IHL also addresses the issue of accountability. Grave breaches, such as targeting civilians, using prohibited weapons, or committing acts of torture, constitute war crimes. International tribunals, such as the International Criminal Tribunal for the Former Yugoslavia, ICTY, and the International Criminal Court, ICC, play a crucial role in prosecuting individuals responsible for such violations. For instance, the ICTY convicted Ratko Mladic for his role in the Srebrenica massacre, ensuring accountability for one of the worst atrocities in modern history. Non-state armed groups are also bound by IHL, even though they are not signatories to treaties. For example, during the Colombian armed conflict, the FARC guerrilla group was held accountable for breaches of IHL, such as the recruitment of child soldiers and attacks on civilians under customary international law. In summary, international humanitarian law is a vital legal framework that protects humanity in the darkest of times during armed conflict. Whether it's safeguarding civilians in Syria, prosecuting war crimes in the former Yugoslavia, or providing aid in Yemen, IHL ensures that even in war there are rules. It reflects a shared commitment to preserving human dignity amid the chaos of conflict. Let's turn to Part 9, Section 1, the United Nations. This section delves into the role of the United Nations, UN, as the central institution in maintaining international peace and security, promoting human rights, and fostering cooperation on global challenges. Established in 1945 after World War II, the UN operates as the primary forum where states collaborate to address issues that transcend national boundaries. At the core of the UN's mission is the UN Charter, which serves as its constitutional document. The Security Council plays a pivotal role in maintaining peace and security. It has the authority to impose sanctions, authorize military action, and deploy peacekeeping missions. A prominent example is the UN's involvement during the Kuwait invasion 1990 to 1991. The Security Council authorized the use of force under Resolution 678 to liberate Kuwait, demonstrating its ability to mobilize collective action in response to aggression. The General Assembly, where all member states have equal representation, functions as a global deliberative body. While its resolutions are non-binding, they carry significant moral and political weight. For example, in response to Russia's annexation of Crimea in 2014, the General Assembly adopted Resolution 68-262, affirming Ukraine's territorial integrity. This resolution showcased the UN's role in shaping international opinion, even when direct enforcement is not possible. Another vital organ is the International Court of Justice, ICJ, the UN's principal judicial body. The ICJ settles disputes between states and provides advisory opinions on legal questions. A notable case is the Nicaragua v. United States 1986 Techter ruling, where the ICJ held that the U.S. had violated international law by supporting Contra rebels. While compliance with ICJ rulings can vary, the court reinforces the legal framework that underpins global governance. The UN is also a leader in human rights protection, spearheaded by the Office of the High Commissioner for Human Rights, OHCHR, and the Human Rights Council. For instance, the UN played a critical role in drafting the Universal Declaration of Human Rights, UDHR, in 1948, which set the foundation for modern human rights law. More recently, UN mechanisms have been instrumental in documenting and addressing human rights violations in crises such as the Syrian civil war. The UN's specialized agencies, such as the World Health Organization, WHO, and the United Nations High Commissioner for Refugees, UNHCR, tackle global challenges ranging from pandemics to refugee crises. During the COVID-19 pandemic, the WHO coordinated international efforts to combat the virus, illustrating the UN's capacity to respond to global emergencies. However, the UN is not without challenges. Issues like the veto power of the 5 permanent members of the Security Council, P5, often lead to gridlock, as seen in the Syrian conflict, where repeated vetoes have hindered decisive action. Nonetheless, the UN remains a vital platform for dialogue, as evidenced by its role in the Paris Agreement, 2015, negotiations on climate change. In summary, the United Nations is the cornerstone of the international system, addressing peace, security, human rights, and development. Through its diverse organs and agencies, from the Security Council's enforcement actions in Kuwait to the WHO's pandemic response, the UN demonstrates its unique ability to unite nations in pursuit of common goals, even amidst the complexities of global politics. Let's move to Part 9, Section 2, International Institutions. This section focuses on the growing importance of international organizations and institutions in managing global challenges, fostering cooperation, and ensuring compliance with international law. While states remain the primary actors in the international system, institutions play a pivotal role in bridging gaps, addressing transnational issues, and creating platforms for negotiation and accountability. One of the most prominent examples of an international institution is the World Trade Organization, WTO, which governs global trade rules. The WTO ensures that trade flows smoothly and fairly, resolving disputes between member states through its dispute settlement body. A key example is the Boeing-Airbus dispute between the United States and the European Union over subsidies to their respective aircraft manufacturers. The WTO provided a platform for both sides to argue their case and issued rulings that helped prevent the escalation of trade wars, illustrating how institutions mediate economic tensions. Another critical institution is the International Monetary Fund, IMF, which assists states in maintaining economic stability. The IMF provides financial assistance and policy advice to countries facing economic crises. For instance, during the 2008 global financial crisis, the IMF played a vital role in stabilizing economies through emergency loans and reforms, such as its bailout program for Greece to prevent a collapse of the Eurozone. The World Health Organization, WHO, is another example, particularly in the context of the COVID-19 pandemic. The WHO coordinated international efforts by disseminating guidelines, facilitating vaccine distribution through initiatives like COVAX, and fostering collaboration between countries to curb the spread of the virus. This highlights the indispensable role of institutions in addressing global health emergencies that transcend national borders. Regional organizations also feature prominently in this section. For example, the European Union, EU, exemplifies how regional institutions can achieve deeper integration among states. Beyond its economic functions, the EU has played a crucial role in promoting human rights, environmental standards, and conflict resolution within Europe. A notable example is the EU's role in mediating between Serbia and Kosovo, fostering dialogue to stabilize relations in the region. The African Union, AU, and the Organization of American States, OAS, are additional examples of how regional institutions address specific challenges within their areas. The AU, for instance, has deployed peacekeeping missions to conflict zones such as Darfur, showcasing its commitment to promoting peace and security on the continent. Lastly, international institutions like the International Criminal Court, ICC, focus on accountability and justice. The ICC prosecutes individuals for grave crimes like genocide, war crimes, and crimes against humanity. For example, the conviction of Thomas Lubanga for the recruitment of child soldiers in the Democratic Republic of the Congo demonstrated the ICC's role in holding perpetrators accountable and reinforcing international norms. In summary, international institutions are vital for fostering cooperation, resolving disputes, and addressing global challenges. From the WTO's trade regulations and the IMF's financial stability efforts to the WHO's pandemic response and the ICC's pursuit of justice, these institutions ensure that states work together to uphold the principles of international law in an increasingly interconnected world. Let's dive into Part 9, Section 3, the United Nations and the Use of Force. This section examines the critical role of the United Nations, UN, in regulating the use of force under international law. The UN Charter, specifically Article 2.4, establishes a fundamental prohibition on the use of force by states, except in two key circumstances: when authorized by the United Nations Security Council, UNSC, or exercised in self-defense under Article 51. The UNSC holds the primary responsibility for maintaining international peace and security, and it can authorize the use of force in response to threats, breaches of peace, or acts of aggression under Chapter 7 of the UN Charter. One of the most well-known examples is the Gulf War, 1990 to 1991. Following Iraq's invasion of Kuwait, the UNSC passed Resolution 678, authorizing a coalition of states to use all necessary means to liberate Kuwait. This action demonstrated the UN's capacity to mobilize collective force to restore international order. The UN also authorizes peacekeeping missions, although these typically involve the use of force only in self-defense or to protect civilians. For example, the UN mission in South Sudan, UMISS, was established to protect civilians and support the peace process in a country plagued by civil war. While peacekeeping missions are not strictly use of force operations, they highlight how the UN engages in military operations to prevent escalation and safeguard vulnerable populations. Another critical aspect is the UNSC's role in responding to humanitarian crises under the doctrine of the responsibility to protect, R2P. A notable example is the Libya intervention in 2011, where the UNSC passed Resolution 1973, authorizing NATO to use force to protect civilians from the Gaddafi regime's violent crackdown during the civil war. While the intervention succeeded in preventing mass atrocities, it also raised questions about overreach and the unintended consequences of regime change, highlighting the complexities of UNSC-authorized force. In contrast, the section also addresses situations where force is used without UN authorization, raising significant legal and political debates. For instance, the 2003 invasion of Iraq by a US-led coalition lacked explicit UNSC approval. The coalition justified the invasion on grounds of enforcing previous UNSC resolutions and addressing weapons of mass destruction. But the legality of this action remains highly controversial, showcasing the challenges of unilateral force in a multilateral system. Finally, the section explores the limitations of the UN system, particularly the veto power held by the 5 permanent members, P5, of the Security Council. This power has often led to deadlock, as seen in the ongoing Syrian civil war, where repeated vetoes by Russia and China have blocked collective action to address the crisis. This highlights the tension between geopolitical interests and the UN's mandate to maintain peace and security. In summary, this section underscores the UN's central role in regulating the use of force and maintaining international peace. From the Gulf War to the Libya intervention, it demonstrates the potential of collective action through the Security Council. However, cases like the Iraq War and Syria showcase the challenges and limitations of the system, emphasizing the need for reform and consistent application of international law in a politically divided world. Understanding international law in its entirety is essential because it governs how nations, organizations, and individuals interact in a complex, interconnected world. International law is not just about treaties or disputes between states. It shapes nearly every aspect of global relations, from peace and security to human rights, trade, the environment, and even technological innovation. Let's break this down. First, international law ensures global stability and peace. By establishing rules against the use of force, fostering dispute resolution mechanisms, and promoting collective security, it creates a framework for preventing conflicts. Take, for example, the United Nations Charter, which prohibits aggression and facilitates diplomatic negotiations. Without these legal guardrails, the world would face constant chaos and war. Second, it protects human rights and dignity. From the Universal Declaration of Human Rights to treaties like the Convention Against Torture, international law safeguards fundamental freedoms and holds perpetrators accountable for atrocities. When courts like the International Criminal Court prosecute war criminals, or when human rights mechanisms address crises like the Rohingya genocide, it is a reminder of the law's role in upholding humanity. Third, it supports global cooperation on pressing issues. Problems like climate change, pandemics, and cybersecurity threats cannot be addressed by one country alone. Treaties like the Paris Agreement or institutions like the World Health Organization provide a unified legal and operational framework for countries to work together. Without these agreements, the collective response to challenges like COVID-19 or global warming would be fragmented and ineffective. Fourth, it regulates economic interactions. International trade laws, like those enforced by the World Trade Organization, ensure fair competition and resolve disputes. For example, the WTO's rules enable small and large economies to trade under agreed principles, fostering economic growth and reducing poverty. International investment treaties also protect businesses from arbitrary actions by foreign governments, promoting stability in global markets. Fifth, it governs shared spaces and resources. International law regulates the use of the high seas, outer space, and the Antarctic to prevent exploitation and conflict. For instance, the United Nations Convention on the Law of the Sea ensures equitable use of maritime resources and the protection of marine biodiversity. Understanding these laws is crucial as humanity ventures into new frontiers like space exploration. Lastly, it brings accountability and justice. International law ensures that states, corporations, and individuals are held accountable for their actions. Whether it's prosecuting crimes against humanity, settling border disputes, or addressing environmental damage caused by multinational corporations, the law provides mechanisms for redress. Understanding international law empowers individuals, policymakers, and organizations to navigate the global system effectively. It allows us to advocate for justice, protect the planet, and build a more equitable and peaceful world. In a time when global challenges are more interconnected than ever, knowing how the rules work is not just beneficial, it's essential.
We're growing fast, and I'd love for you to be part of this amazing community. Subscribe, and I will see you guys again soon.